such clear cases, in a large batch cases where there is no particular pointing of the finger at the accused himself, then delay will trump statute. And that principle is very well done in a series of PMLA cases and in Najib. And I don't
have today with us Dr. Singhvi, a very prominent and able lawyer, both in criminal law and commercial and other matters. We are fortunate to have him here and to talk about the Gulfisha Fatima case, more popularly known as Umar Khalid's case. Dr. Singhvi, you argued the Gulfisha Fatima's case. What are your first reactions to that judgment?
Thank you, Anand, for a generous introduction. Obviously, a mixed bag of emotions. Happy for the fact that the lead matter, which I argued, Gulfisha's matter, led to a positive result. She's a young girl, and I was very touched when she came with her brother to meet me. The first time I ever met her was after the order. I've never met her before, and I felt relieved that a girl with a whole career in front of her has got liberty. The mixed bag because I was equally sad that people who had been in the batch for 5 years plus did not succeed. If you ask me, Anand, I believe that almost as a per se rule. Per se means including special acts. And the bail provisions or the anti-bail provisions in so-called special acts like PMLA or narcotics or this UAPA are pretty similar. They're not dissimilar as far as bail is concerned. I believe that including those acts, anything which involves a 5-year pre-conviction incarceration, it should lead to bail. The only exception I would put there on a per se rule is where there is an unimaginable situation with very clear evidence. Take, for example, Kasab's case. You had a one camera, you had a situation there. Maybe barring such exceptional cases, or a child rapist caught on camera, that kind of which are rare situations, I would say that a 5-year pre-conviction can never lead to denial of bail because you are still pre-conviction. It turns on its head the very concept of presumption of innocence. It turns on its head the very concept of the fact that this is pre-conviction under trial. Then there is no difference between a 319 post-conviction suspension of sentence versus a pre-conviction incarceration. So you have to maintain the decision. 5 is a pretty long time. Lastly, there are all powers available with you to subject a person who is even accused of such special act crimes to all kinds of regulatory limitations, which cannot possibly impinge on public safety and on the focus of that special act under which I am incarcerating you. There is nothing today. Passport goes for the asking. Travel restrictions are there. My reporting to you is commonplace any number of times. And frankly, I have been advocating technological use. As a matter of fact, let me digress for 2 minutes. According to me, a lot of our overcrowded prisons and a lot of our bail jurisprudence would change if you were to partially, as a pilot project, adopt what they do commonly in the West. Put the anklets, put the GPSs, and even for serious crimes, give liberty under very controlled conditions. The anklets can be tuned, if you know, even to the house, even to a room in the house, even
Dr.
to the building in the building.
Yeah, thank you for actually digressing, but that's a topic for another conversation. I wanted to ask you whether your term of 5 years, which you are advocating, is a general term because that's larger than some of the judgments have advocated.
I cannot give it as an absolute rule, but I would put it like a judge-made presumptive rule that absent the very extreme examples I have given, like a kasab caught on camera fully, or something which goes to the sovereignty of the nation with that kind of evidence, absent those categories, a judge-made rule of the thumb should never allow a denial of bail for a 5-year plus situation. Now, obviously, there will be exceptions. I mean, I can, a theoretical exception of 1 or 2% cases does not change my rule.
So the only reason I'm interrupting on this point is because some, like Antil's case and all, they've advocated 3 years. So I wanted to know your reaction because 5 years, I think, is a longer period then I would have
I'm
read it.
sorry, you misunderstood. I
I'm sorry.
thought I am saying that 5 years in this category of cases.
Okay, okay,
Otherwise, of course, I would say that if it is a general rule, 3 years is a good rule,
okay, fine. I
or
think,
4 is a good rule. I said
yeah,
that it can never be that in a 5 year batch of cases like this you will deny
yeah,
bail.
yeah, yeah.
That is what I
Thank you.
meant. That's it.
That's very
Yes.
important to clarify. Thank you very much. Dr. Singhvi, what about the judgment on the issue, first of all, of actually rereading or reading Najib, contrary to what Najib actually
Now,
settles as a rule?
now let's look at Najib, which is the same act. But also remember, the broad structure of the denial of bail provisions are not very different, including PMLA.
Yes,
And
absolutely
I've
right.
had the privilege of arguing for Kejriwal, for whom I got bail twice, for Manish Sisodia, for Sanjay Singh, and many other cases. Now, what is the thrust of them? Take Manish Sisodia's simpler case first. That delay, since it goes into Article 21, will trump a situation of a special act anti bail provision because 21 stands on a higher footing. That's the principle underlying this. The same principle is applied in Najib. Delay per se of an unconscious. Now, obviously, there can be cases where all the delay is by Anand Grover. Every delay is done by him. Then he can't take advantage of that. But barring such clear cases, in a large batch cases where there is no particular pointing of the finger at the accused himself, then delay will trump
Mm,
statutory rights because it goes and sits inside a higher constitutional provision 21. And that thing, that principle is very well done in a series of PMLA cases and in Najib. And I don't think that that has been in spirit adhered to at all here.
mm,
This judgment has a lot of adjectives, a lot of you know uh, value judgment phrases, but they do not take the place of the objective tests of delay. It is nowhere shown, for example. I mean, I would have accepted the judgment had it shown that these two persons, Sharjeel and this fellow Umar Khalid, by this chart of dates, delayed their trial. There is no such analysis.
mm.
And the
Yeah,
fourth thing which I want to emphasize is that where the person who is seeking bail has this exceptional case, as in this batch, that he was in jail when the events took place. Now, if you are in jail, Anand, when the events take place, there can be only one exception where something is recovered from your vicinity in your hands or in your pocket or under the charpai in the jail. Or you are filmed as saying, now I am telling you, carry the bomb from here to there. Absent that kind of evidence, there cannot be anything resembling an overt act which can lead to denial of bail for a person who was in jail when these events took place.
now you're getting onto the merits. Now, that's important. I'm glad you clarified the fact that Najib's rule still stands. We'll come back to that later. Now, what about the fact that the whole issue of the expression in Section 15 by any other means has got a very expanded and very unclear meaning in this judgment? What is your reaction to that?
See, wrong both on law and on the application of that principle in this case. Unless you read by any other means, I mean, it's not right to use Latin phrases for meant for civil law like ejusdem generis and all. I'm not on that. But obviously, the means have to have a broad nexus with the kind of preceding words.
Yes.
Any other means cannot mean a subjectivity which is at large from case to case as a
Mm,
as a residual legatee of infinite proportions.
mm,
Then that it would swallow up the entire provision. If you were to interpret those four words as a residual legatee of a subjective wide interpretation, then it will swallow up the entire section. So
mm.
it's very clear that any other means have to be of the kind. They
Yeah.
have to at least share a species. Um, I mean, they have to be of the same species, same kind. Otherwise, it makes a mockery of the provision.
Yes. So there again, the judgment is wrong. And now, lastly, on the issue of hierarchy, in terms of Umar Khalid and Sharjeel Islam being considered to be ringleaders or whatever ideological leaders, and reading into conspiracy, a structured difference between leaders and those who are led. I mean, what do you have to say about that?
See, there are two answers there, Anand. In principle, it may not be wrong, but the way it is used and applied in this case, it is wrong. I'll tell you why. You see, first of all, these are the part of the subjective embellishments of language which you find various places in the judgment, very well written in English, and these fancy words like hierarchy used. But what do they boil down to? Hierarchy is not a new word; it's been used in criminal jurisprudence for a long time. A ringleader may well get a conviction which others may not. A ringleader will get a sentence which others may not. So it's a commonsensical thing. The real problem here is that of the two ringleaders, one is in incarceration when this happens. So merely using the word hierarchy, you have to follow up with giving specific facts, either of a conspiracy which makes a full blueprint that you'll put a bomb here and do this, or of finding something. That you have not done. You use the word hierarchy.
Yes.
Secondly, you have also not individuated the facts, which suggest that these people did something so obviously in the planning. There are no facts I find that they are the kingpins who orchestrated everything while masses of people have got away. There are many people who are acquitted in the lower courts as not part of the conspiracy. So the facts are missing. These adjectives have taken the place of facts, is my problem.
Okay. Now, how do you deal with a judgment like this as a lawyer? Because some judges will cite this judgment and some judges will actually cite Najib. How do you get out of this impasse
That's
as
going
a
to be a
lawyer?
that's going to be a major problem because I have always complained against the inconsistency of bail jurisprudence. For every judgment, it's now become a situation. You show me the color of your hair, and I'll show you the judgment. And that is
Yes.
very bad. That consistency is a must. This is going to wreak havoc in the consistency. You are right, absolutely, but there is no way you can control it unless, judges collectively, start looking at things in a real way or there is a law, neither of which is going to happen.
What
Today,
about,
there is a very strong line of authority which allows you to go in the proper way on delay from all these PMLA judgments, read with Najib and a few other judgments. But this has set the clock back for a long time.
yes. So, what do you think is the role of the Bar Association and the judiciary put together? Can they not resolve this in terms of laying down guidelines, how the judges should decide judgments? Is there a way out there?
Look, you know very well, Anand, that there are sermons from the pulpit and there are lectures and there are seminars where all those guidelines are laid down in the abstract. You
I see.
also know that most of them are not followed whenever push comes to shove. Now, what is happening is, have we not had enough Chief Justices saying that bail must be the rule, not the exception? We believe that the trial courts are scared that if they give bail, we will think that they have been corrupted. We believe that many of these bail matters should not reach the Supreme Court at all. We believe that there need not be 200-page judgments on bail. It's a straight, rough and ready thing. We believe that there should not be 5-year delays in deciding bail. So all these sermons and guidelines are there. I've repeated 5 of them just now in 2 minutes. But the point is that whenever the acid test comes, you have to go back to them and apply them, irrespective of the weight of the case, the political color of the case, the magnitude of the case, the seriousness with which the government and the law officers are pushing it. All that doesn't happen in practice.
Yes.
Now, I do not see any way out for it unless there is a kind of an almost a nationwide campaign within the judiciary to be consistent. The overwhelming weight of the law, as stated in principle, is in favor of bail, even in such serious cases. But in practice, every day, every week, there are aberrations.
Yes. Last question, Dr. Singhvi. What would you say to a lawyer who will say, if I happen to come before a judge who doesn't follow the law as it is laid down, it's bad luck for him. There's no consistency. What do I do?
Well, I mean, one is appeal, second appeal, review, curative. That is one. The other is, don't lose heart, try, persist, and do your best. The rest you have to ultimately the system works on the basis that they decide and you don't decide. I can't say more than that. I do think that on all these judicial academies, in all these seminars, a time has come when uniformity in bail jurisprudence should be something which is a taught subject, a discussed subject collectively across India from judges. Because how a Delhi High Court judge may decide is very different from how a Jabalpur High Court judge will decide. How a Jabalpur High Court judge will decide very different from Kerala High Court judge will decide. I'm just talking of the High Court for the time being. That non-uniformity may become much more if we go to the district courts. So I think in these sensitization and training programs, the time has come, that's one way out for the longer term, or at least the medium term, to get these people together and say, okay, look, these basic 5 guidelines of bail jurisprudence you cannot and should not violate. Obviously, a
Okay.
discussion is left on the facts, but
Yeah.
broad
Well,
guidelines should be there.
yes. Well, that was wonderful, Dr. Singhvi. Thank you for sharing your thoughts. I think these are needed and more interaction. You are watching the leaflet, and we have the fortunate position to be able to discuss with Dr. Singhvi, and we thank him for sharing his valuable thoughts. Thank you very much.
Thank you so much. Thank you. Thanks a lot.
Many of our authors and well-wishers have often told us that they started their legal writing careers with the Lawyer's Magazine, a one-of-a-kind publication started in 1986, which really showed us what critical legal journalism in India can look like. For 7 years, the leaflet has continued to build on that legacy. And in a time which is proving to be precarious for our courts, our legal institutions, our journalism has kept the Constitution first. So your support for the leaflet means a lot. It means that we can bring more hard-hitting investigations, more video stories, more expert analyses on issues plaguing our courts and our democratic polity. So support the leaflet, subscribe to the leaflet, subscribe to our YouTube channel, join us on WhatsApp and Telegram, and join us in this journey of keeping the Constitution first.